most welcome. This is very important issue, and we want to see what can we do. There's no press here. It's only stakeholders who are here. So whole idea is that what solution we can find. What I would like to do is to just start with some introduction. We have Mr. Swansingh Parameswar. He is the Vice Chairman of Financial Services Commission in Mauritius. We have Prakash. He's a CEO. He's hands-on, so he knows all the technicalities going on. Mr. Kuriachan, he represents EDB and also Financial Services Commission in Bombay, so you can catch hold of his neck whenever necessary. And we also have, I think, Mr. Nandlal. Yeah, exactly, from the Consul, it's the External Ministry, and from Mauritius. So whole idea is to discuss the framework and then see what can we do to solve this problem, rather than it's been quite a bit of, I think, time that we thought this was not a big issue to resolve, really speaking, if you logically, but somewhere on the line things have gone on and on and on, and we should see that. What I would like to do is just to set a tone. I will request Richie to restate the problem, and we are all on the same page. And if anybody has any question on the facts or anything like that, maybe you can ask. And then maybe I would request Mr. Kuriachan to say a few words. Yeah. Oh, sorry. My apologies. I just came straight from flight, went home, took shower. So you can see sometimes little less sleep disorients you. So my apologies for that. No. So, Richie, why don't you start and talk a little bit about,
I think a lot of these
setting
issues...
the tone.
Yeah, sure. I'll just quickly summarize what the issue we are facing with. It all started with the April 10th circular from SEBI, which sort of wanted to clarify the position of beneficial ownership, how KYC processes have to be undertaken when you are dealing with intermediaries like FPIs. So there they start by saying that when you're looking at KYC processes, you strictly try to identify who the beneficial owners are, and that's where they refer to the PMLA regulations. So they go on the expected lines to say that beneficial owner is anyone who is having material ownership thresholds on the FPI, where they refer to the expected lines of 25% in case of companies, 15% in case of trust and partnerships. Then they also sort of just restate the position that these tests apply on a look-through basis. On the control aspect, they go on the expected lines, where they say that control is anyone who, through voting arrangements, through contractual arrangements, can decide who's going to sit on the board of the company, can decide what the management affairs of the company, how they're going to be run, and so on and so forth, are the ones whom you identify as the beneficial owners on the control side. And they again, on very expected lines, go on to say that if you don't identify any beneficial owner on the basis of material ownership thresholds, or nobody you identify on the basis of control, you identify who the senior management officers are. And this typically would mean the board of directors or the designated partners or the general partner in case of a limited partnership sort of a construct. Where the circular then goes beyond the threshold is that instead of looking at the entire PMLA framework for carrying out KYC, in case somebody breaches those thresholds, you report them, you identify them, you get them reported under the tables and so on and so forth, enforce a deeper KYC on them. They go on to say that if the KYC points to an NRI or a person of Indian origin, then there is a problem. On ownership side, they are saying an NRIs or PIOs, technically, cannot be the beneficial owner from an ownership perspective of an FPI. That's the first point. They clarify that Indian residents can also not be beneficial owners of an FPI. Second point. The third point they say is that if on a control basis, an entity which is controlling the FPI is owned by an NRIs, either majority or wholly owned by them, then such structures need to mandatorily get registered with SEBI as a non-investing FPI. This is absolutely similar to the arrangement that happened before the FPI regime under the FI subaccount framework, where FIs, global banks, or entities which were management in nature used to sponsor subaccounts. So FIs were meant for managers and banks. Subaccounts were meant for the portfolios which were investing in India. So it refers back to the same arrangement where NRI-owned vehicles can only be the managers or non-investing FPIs, whereas The FPIs have to be the fund vehicles. Uh, they don't make any clarifications for resident Indians. What it technically means is that while NRI owned structures can still continue as managers of FPIs, and NRI ownership structures cannot. There are severe implications of this, obviously, which is why we are all assembled here. There are other clarifications also that the circular tends goes on to make. The first one is that control now has been left little wider interpretation and open. It's not linked to takeover code definitions and so on and so forth. Control means, like I said, anyone who can decide the management affairs of the entity or gets to decide who on the board is going to be. Now, from SEBI's perspective, while they are fine with NRI owned structures managing FPIs, in their mind it seems to be a contractual arrangement where, let's say, you're a portfolio manager who can make buy and sell recommendations. In their mind, a fund manager is a little different. Fund manager is somebody who sets up the platform, holds the voting shares, decides which LPs to market to. If some LPs want a redemption, go ahead, market the fund to lot many more other LPs and so on and so forth. That is somewhat larger role than what they have in their mind to allow NRIs to operate on. In their minds, they want NRIs only to be a portfolio manager. At least that's what the mindset was when we first saw the circular and we started engaging with SEBI. Obviously, a lot has happened. A lot has happened. We have been discussing with SEBI what the interpretations have been. We now understand that the third limb of senior management officers only needs to be identified if you didn't identify somebody on the ownership or the control side. On voting shares, there are some views emerging, but look at ownership, look at control as two separate buckets, and that's it. Let's not confuse voting shares with too many other issues, but again, we'll be happy to discuss what those interpretations mean. And the last one, obviously, is the deadline that we have in front of us. While on futures and options, there was a rollover period. From April onwards, you could not roll over if the structure is not kosher. For cash equities and so on and so forth, we still have October 9 as the deadline before which we roll over. There obviously are a lot of solutions also being discussed in the industry. Some could range from transfer of voting shares, some could range from partnering with an offshore JV partner, some could range up to can we have a domestic structure like an AIF which could work. But again, that's a phase two exercise. Phase one is how can we sort of, what sense can we make out of this SEBI circular? How can we sort of make sure that our structure comes to grips with this circular? If it does not, then what are the alternatives out there? Which, like we said, is a phase two exercise. Having said that, given that we are less than a couple of months away from the deadline, the phase two is very, very real and something that everyone is now contemplating. With that, I think I'll again pass on to.
I think what I think will be useful for Vice Chairperson of FSC, Justice Swan Singh talks and we get into it. It would be good to make it a little informal and if you can just have a little introduction so we all know who's who in the room. Quick introduction. So, Path, maybe.
Right, Part Family, I run a fund called Aeon Capital. It's a private equity fund.
I'm Neeraj Choksi, the promoter of NJ India Investment. We also run a fund in Mauritius, NJ Global Opportunities Fund.
Because such they were in our asset management. We have a fund in Mauritius as well.
Jiten Doshi in our asset company. We have funded.
Manish from ICICI Bank on the custodial side. I head the custody business. Deepika is my colleague for the custody part.
In Rasul from BNP, I head the compliance for
Amar Kampani from Kotak.
Rohan from Malabar Investments. We have a FPI vehicle in Mauritius.
Sunil from HDFC Bank.
I'm Vipin Advani from New York.
Deepa from Deutsche Bank. Vaishali Babu, head the products and market intelligence from BNP Custody.
I'm Sivraj Mangra from Mauritius. I'm based in New Delhi, heading the economic development role, which is under the Prime Minister's office.
I am Tejas Desai, partner at EY Financial Services Tech.
Hi, this is Anand from Wilson Financial Services. We just got an FPI Live. NDA is the company.
Hi, Neha Mathur. I work for Wilson Financial Services.
Hi, Anand Modi, Wilson Financial Services.
I'm Jaykumar from Market Equity Consultancy. We manage international mutual fund book fund, which is rooted through Mauritius.
Yeah, I work with.
Hi, I'm Ashish Daruda from Citibank Custody.
Hi, Clinton Davis, also from Citibank Custody.
Prashant Khanchandani from Standard Chartered Bank Custody.
I'm Ruchik and I lead the investment funds practice at the firm.
This is JD Pan from Standard Chartered Custody Services.
I'm Nandini. I also am a part of the fund formation practice.
Hi, I'm Irfan. I'm part of the tax and funds team. I'm Kishore. I am the regulatory practice at Nishith Desai Associates.
So I think we have some tone setting. Reggie, thank you very much for that. And can we have you say a few words and then we can open up. So whole idea is that if you have any idea as to how should we go about what, and we'll also tell you what we are thinking. So you can do.
Thank you, Nishith, and good morning to you, everybody. In fact, as Nishith just introduced me, I am the board director of FSC, and I'm designated, in fact, by chairperson, not yet appointed as such. But I'm also the deputy permanent secretary of the Ministry of Financial Services and Good Governance, which means I'm wearing two hats, sort of. And I look at these issues from a policy perspective. In fact, when I'm from the ministry, I know if, for instance, if you have to amend any rules, regulations, laws, measures, basically, then we advise government and we go through all the process of parliament and do it. What I've been given is sort of a note to read to you, and I will first start with that, and then we can start. I'm just reading it because it is from the FSC. Sure. I'm a board representative here, and I would like to read it, and then from there, what I suggest, whatever discussions, because I'm not a technical person, I inform you, I'm not a technical person in that board. I'm from administration and from the ministry, but responsible for all that. And what I would like you guys, whatever questions, very technical questions you have, my two friends here, Mr. Prakash Sivankar, who is a COO of the FSC, he has a long career there, and Mr. Koya Chan, who is our representative in Mumbai, based in Mumbai itself. They are our technical guys who can try to answer you. But as I said, we are not here to change the rules, and we are in a sort of a listening mode. We'll take note of any suggestions you might have, and then try to see how best we can, what best we can do to either deal with SEBI, or because we have an MOU with SEBI. In fact, we meet them regularly. I tell you in my note here, and even if in Mauritius, I have to advise the government of Mauritius, my minister and the government, what needs to be done. We are going to do that the best we can, as we have been doing. So let me just read this very note. In fact, it's my immense pleasure to be here and this morning. And at the very outset, I would like to put on record the unique historical, economic, and cultural ties shared by Mauritius and India. Our nations have, over the past decades, consolidated its diplomatic relations, and this exceptional bond will undoubtedly be reinforced in the future. It is also important to highlight the unfailing support of India in contributing towards the socio-economic development of Mauritius. It is true that for more than 30 years, the existing Double Tax Avoidance Agreement, DTAA, has served the interests of both our countries. It has helped Mauritius in the development of its financial services sector and also benefited India in terms of foreign direct investment. Its revision in 2016 has marked another era of mutual cooperation, thus opening up new opportunities for India and Mauritius. Mauritius is today recognized as an international financial center for investments into Africa and Asia. The jurisdiction has created a business-enabling environment that is internationally competitive, transparent, and respectful of international standards. Mauritius features highly in international ratings in the African continent in many indicators and indices computed by reputable independent institutions. The business enabling environment in Mauritius provides clarity for investors and allows for efficient and cost-effective registration and operation of businesses. Furthermore, Mauritian service providers have gathered expertise in the financial services industry through a long history of successful commercial dealings. The government of Mauritius is fully committed to ensure the compliance of our jurisdiction with the best international norms and standards. We are proud of the recognition of Mauritius in 2017 as an OECD-compliant jurisdiction for its continued commitment to implement the international standards of transparency and exchange of information for tax purposes. Indeed, a lot of measures aimed at reinforcing Mauritius as a well-regulated and reputed jurisdiction have been implemented over the years. Recently, our government has taken the policy decision to reform our legislative framework, including the framework relating to financial services and the global business sector, so as to be in compliance with the base erosion and profit shifting and other standards, thus enhancing our reputation. Mauritius will continue, whenever required, to revisit its legislative and institutional framework with a view to reinforcing financial supervision, enhancing transparency, and strengthening the regimes to fight tax evasion, money laundering, and other financial crimes. Coming back to the recent mission led by the Financial Services Commission in India, we are very appreciative of the assurance given by the Securities and Exchange Board of India that it has no adverse concerns with respect to the Mauritius jurisdiction. SEBI further reaffirmed that it is neither working on nor contemplating to produce any list at its level, which will identify Mauritius as a high-risk jurisdiction. Both the FSC and SEBI will reinforce the collaboration in regulatory matters and exchange of information. On the political front, bilateral discussions have already been engaged between our respective governments, and Mauritius is committed to take the necessary measures to dispel any potential ambiguity which may impact on its collaboration with India. Ladies and gentlemen, Mauritius offers a myriad of opportunities for investment and business. By using the Mauritian platform, Indian companies will be able to make sustained inroads into the African continent. We encourage you to partner with us to invest in those new frontiers of opportunities and growth. In fact, I had to read it, and Mr. Avesh Chigulam, who is the chief executive of FSC, he couldn't make it. He apologized for it, and in fact, he very much wanted to. We met him in Mauritius, but he has a meeting this morning with the Prime Minister. And unfortunately, this meeting has been rescheduled, and he wanted to even Skype call and have a chat here with you. Sure. But unfortunately, he has been called a bit earlier to meet the Prime Minister this morning. So he couldn't make it. So I would have liked him also to be here and talk to you, because he's very much versed with this subject, and he would have given you a very good piece of more detailed information, more insight of what is happening. And but for us, when we met SEBI last time, we got the reassurance sort of that they never intended to, as they now intend to. They never intended nor intend to work in any list where they are going to put Mauritius as a high-risk jurisdiction. So it's what we understand. It's a list prepared by the banks themselves, by the custodians. And now I understand that I read from the news last time, I can confirm it, that they have asked, have gone back to the previous model. That is, the banks themselves, they prepare their own list of being high risk, low risk, or medium risk, and not civic. It's not is common list as such.
So if I may just, Prakash, do you have anything to say at this point in time? Then I can.
I just wanted to just, Avish personally conveyed his apologies again, and very much wanted to hear. I think what is very important from the FSC's perspective is that we have a very long relationship with India and with SEBI that dates back 2001, 2002, when FSC was formally, we signed the MOUs. I think any issues that comes with respect to our relationship is considered at the highest level. And we do take all these issues very seriously, and I think our visit to India testifies our commitment to ensure that any issues that may arise in this relationship and in the way businesses operate through Mauritius, we are very keen to find a solution, and we can assure you our best support on these matters, and we are here to listen and do whatever is required. And I think recently we opened an office in India. Mr. Kuriachan is now based, so you have someone who would be here, and Mr. Kuriachan regularly communicates with us and shows that. I think in the recent meeting with the industry in Mauritius, everyone was very happy that we reacted very promptly, and they were very happy that we had taken the matter seriously, and we sent a delegation headed by the chief executive of FSC, Mr. Parmesa, who is the vice chairperson designate as well. So I think the commitment of FSC in resolving any issues that the industry might feel that is aggrieved we are here to provide our support. And we are here to listen and try to, and also if they, our commitment is through the delegations that we have. So we have the EDB, the Ministry of Foreign Affairs, FSC's office, and ourselves here. So we are here to listen. So that's
Okay, Richie, why don't you come here so we can talk?
Yeah, please.
If I may just look to a few points here. I think there are two levels of engagement. One, of course, with Mauritius, that's why they are here, political or otherwise. You know, I think this week, I think Sushma Swaraj and others are going to be in Mauritius, and issue will also be taken up. So one is engagement at that level. Other is the stakeholder level. So I think this has a dual purpose. So instead of meeting separately and all that, we thought it would be useful that something will, whatever we expect Mauritius to do, they will be very happy to do. And whatever we need to do, I think we need to move a little faster, and we are not able to see sufficient buy-in from Indian government side. It is stuck somewhere in between, and we need to just see what can we do so that any issues there can be resolved, and concerns of everybody is taken into account. Uh, I have some problems fundamentally with this circular. It talks about high risk jurisdiction. That's the first point. And the way in which I'm looking at, they have not defined what is high risk jurisdiction. It is left to the custodians of the banks. Now, perhaps custodian in India or in Mauritius also cannot figure out. They said that it goes to their compliance department somewhere. Well, I believe Citibank doesn't have a presence in Mauritius. Some other banks do have presence in Mauritius. So there is no criteria for high risk jurisdiction. I would not have any problem in delegating that to the bank. But when it becomes part of a regulation, that if it's a high risk jurisdiction, then it is SEBI's responsibility to either define. I think this is the first point we need to say, that you tell us, because if now, for example, out of 10 banks, 7 or 8 banks think it is not a high risk jurisdiction. Okay, 2-3 banks think they are high risk jurisdiction. How can an action be taken? You leave it to different banks, and therefore you create a chaos, because some people say it is not. So you move one account to the other and stuff like that, and therefore, I think so. Responsibility of SEBI is to give a proper definitional context. Number one, and different banks may have different reasons for doing number of different things. It may be, if it is perception driven, it becomes very difficult to deal with. Okay, perception. But if there are certain criteria, then there must be some commonalities. Then you can compare. I think so. First thing we should be talking to SEBI is that please give us definitional context. Second, when high risk jurisdiction is criteria for applicability of certain regulations, okay, you cannot delegate to a bank to say that you decide, because it is like the powers, kind of regulatory powers, legislative powers that SEBI has, it is delegating to the, you cannot do it. It is your responsibility. So even again that either you say, okay, you decide, and whatever is the high risk jurisdiction. But if it is a part of regulation, that we have to get some kind of clarity. Second is that, again, the thing personal or otherwise, but what is relevant? Is it high risk jurisdiction or high risk bank? Okay, the custodians are here, so I'm just trying to look at legalities. That if you say high risk jurisdiction, what is high risk jurisdiction? Now, in my view, if the jurisdiction doesn't have rules or regulation or legal framework, correct, and therefore enforcement is weak. So if you do not have a framework of law at all, and then it would be high risk jurisdiction. But what is the job of a government? To put in place a framework of regulation and put in place enforcement machinery. If those two things are done, then you cannot say it's a high risk jurisdiction. Unless you say that enforcement machinery is also not effective. That has happened in India sometimes. Laws are there, but they are not enforced. India has also been classified as high risk jurisdiction. Several banks have done it, right? And I'm not being judgmental here, and maybe rightly so. Does it mean that India should not get investment at all? Because if we are high risk jurisdiction, no investment should come to India under the rules. So I think this whole issue we need to really address and nail it down to the SEBI or government. That please tell us, what do you mean by high risk jurisdiction? Okay. In the earlier circulars, somewhere they talked about some high risk jurisdiction. If it is a tax haven,
correct.
If it is something, some other
financial center.
Correct.
offshore financial center,
So the
etc.
PML actually defines what is high risk, but it is very
Vague.
Subjective.
And what we requested SEBI in the past is to kind of make it more concrete.
Exactly.
So I think that should be the way to go.
So therefore, to get to I'll just tell you in a minute. If you look at tax haven, okay, you know the definition of tax haven originally started off saying that if the headline tax rate in a particular jurisdiction is half of the normal ones. Suppose at that time, most of the time, what happened? Most countries have like 50%, 60% tax rate, and if you had half the rate, it was considered tax haven. Like Isle of Man, Jersey, they had like 20% tax rate domestic, or otherwise zero tax on the ring fencing and stuff like that. So then tax rates came down a bit. So 15% became the norm. If you had tax rate below 15%, then it was tax haven. Not statutorily defined, but that is how it was OECD and others considered. Today, what has happened? US is bringing down tax rates to 21% this year. You know, England has gone to 19%. It will come down to 17%. Okay, most countries are bringing down tax rates. So 17% and Mauritius 15%. What is the difference? Right. So they are all tax havens. So contextually, what was done in PMLA perhaps about 5, 10, 15 years ago has also undergone change. Now there is no longer, in fact, I was speaking on tax rate wars just last week at one of the institutions. And the thing is that all countries have, India is coming to 25%. In 1970-71, we had 97.5% tax rate with disallowances, with super tax, surcharge, surtax, everything. We had 102% tax rate. So some people paid that, but after that we decided we'll never tax anybody more than 100%. This is just a little fun. So, you know, the whole concept of tax rate has now disappeared. The focus has moved to two things. There should be no ring fencing. That means you cannot have separate benefit for non-residents, separate for the locals. You have one single regime. So Mauritius also has, locally also is 15%, foreigners also 15%.
Yeah.
Okay. Second thing, the focus has moved from tax rate to exchange of information. To exchange of information internationally. That means if country is not cooperating when there is money laundering or anything happening, that is what is the high risk jurisdiction. Now, as far as Mauritius is concerned, it is the most cooperative jurisdiction. It is member of IOSCO. Not only that, it has good tax treaty with India, and in fact, our understanding is that Indian tax officials are also sitting in Mauritius. So that is, they have gone a step beyond. So when you know they are compliant with all the OECD and other kind of stuff. So as far as Mauritius is concerned, there is a full justification to say that this is not a high risk jurisdiction. And if after having a regulatory framework, enforcement mechanism, even very few cases have been identified and taken up. So if you see 30-year history, right from the time treaty began to get used in 1991, very few cases have come up. But every time cases have come up, they have been dealt with. Things will always go wrong somewhere, every country. but whether country is taking action or not. So country has taken action. They have been cooperative with SEBI. They have been cooperative with tax department and all throughout. And on the top of it, now even the tax treaty has changed so that the capital gains tax benefit that used to exist for sale of shares, etc., is now no longer there. So, it is genuine business reason why people go there, because it become now well-known low cost jurisdiction with proper framework and all that. So I think that is the background. I thought it would be worthwhile taking up properly with SEBI and also at political or otherwise level, because difficulty is that this whole issue of high risk jurisdiction is also maligning the reputation of a country. If I tell a bank is high risk bank, it would hurt you, right? So if you have a framework in place, then who has to follow? It's the banks. Okay. So if banks are not complying, they would be considered high risk bank. Now would I call Citibank or somebody else high risk bank? It would look nonsensical. So I think we need to have this conceptual clarity, and in absence of that, you cannot apply regulations. So I think this is what would be my preliminary comments, and then we'll go into the.
Yeah.
And I think he had a point. I'm sorry for interruption. Please.
I think all very valid points. I was just thinking, if we want to have an outcome at the end of this session, then I think a lot of water has flowed under the bridge since April 10. I think a lot of people in this room, including myself, have been to SEBI, have been to Finance Ministry, pointing out to them, saying what is the problem with the circular. I think there is some understanding on SEBI's part that all of it necessarily is not correct and they need to rectify. But there are some aspects, which they are not able to see reason. So I thought what we can do is maybe share what each one of us has heard in the meetings with SEBI, and then identify what are the 2 or 3 main areas where we see there is a challenge, and then maybe discuss how we want to take it up and with whom we want to take it up.
See, Tejas, I think the other issue here is that what motivates this circular. Like, if we know what is SEBI trying to achieve out of this circular, then a lot of the discussions can also be that much more constructive. I think one facet of the circular was focused on high risk jurisdiction, beneficial ownership thresholds dropping down if you're coming from the high risk jurisdiction, so to speak. But the bigger issue is that they have now ruled out Indian residents from managing global pools. They have put a lot of stringent measures in place, even if NRIs or persons of Indian origin, which are 2 degrees, 3 degrees removed from Indian citizenship, passport, etc. A lot of stringent restrictions even on them managing offshore pools of capital. So what is it that the regulator is trying to convey? Are they saying that there is a particular brand of FPI capital that they want to see flow in India? Do they want to restrict Indian residents and NRIs to AIF structures? Because on one hand, Indian agencies, the government agencies, whether it is Ministry of Finance, SEBI or tax, they've all come together. Tax department has given pass-through status to AIFs in certain situations. SEBI has now allowed an extremely light touch regulation on AIF regulations. MOF has allowed direct foreign investments to come in without any approvals to the AIF regime. We are talking about the same offshore capital pouring into India, getting invested into opportunities, managed by Indian residents or NRI owned entities, yet the same framework does not operate on an FPI level. There we are saying that NRIs or Indian residents, you are not welcome anymore to manage pools of money getting invested in India under the FPI route. Yet on the other hand, we are trying to encourage the AIF industry, which obviously works very well for domestic fund managers. But what is the theme? What is the message we are trying to drive here? That's the first question. Is that what is that motivates SEBI to come out with this circular? The second theme is that, again, from the tax department, we saw circulars that they want to onshore the fund management industry. They want to sort of make a case that how we can do without Mauritius or Singapore or offshore structures, if at all there was one theme to play on their minds. Obviously, the relations have been great and they want to encourage the flows, but on one hand, they're encouraging GIFT as a parallel platform. They're trying to allow Indian managers to directly manage offshore capital. Under the tax act, there was a regime started 3 years back, which allowed Indian managers to manage offshore capital without creating a tax exposure in India. Yet, we have not seen any successful applications in this case. So, on one hand, are they trying to promote Indian management of offshore pool, or are they trying to discourage the entire framework with the SEBI circular that has come out? So the point is that the messaging coming out from the different arms of the regulator seems to be in contradiction with each other. The tax department, Minister of Finance, the view that we are getting from them versus what this circular is supposed to make us understand seems to be in a different tangent altogether. So if we can also understand what SEBI is thinking or where they're coming from, then we can even discuss how we can help and assist the regulator.
So now we can open up to, I think, comments.
Shall I?
Please.
So I think so. We've had a few discussions, on the circular, and some of the people in this room were also there. And I think what we say should remain in this room. But a group of fund managers had a meeting with Piyush Goyal immediately after the circular came out, and I think the main point there was that why are you discriminating against NRIs? There seems to be no logical reason to do that, and all that emanated from the definition of control in the PMLA, which basically says that if you have voting rights, then you are a beneficial owner, and then an NRI or a resident cannot be a beneficial owner. So that is what led to a kind of a ban on NRI stroke resident fund managers managing FPI money. On that point, I think the finance minister was absolutely convinced to say that this does not make sense. If this definition of control has been imported from the PMLA rules, then we need to relook at that. I think that part he was clear, at least in the meeting. He instructed people saying that this should be rectified. And I think at least in subsequent discussions with SEBI, they seem to acknowledge that that is something that they will rectify. So they will allow per se NRI stroke residents to manage FPI money. I think what I have heard at least, and people can add here, but what they now want to say is that the fund manager who's NRI owned or an NRI himself cannot be located in a high risk jurisdiction. So that is the latest thinking, at least we've heard from SEBI. And of course, this whole controversy around high risk jurisdiction, like Nishith pointed out, that continues to remain because SEBI did not want to define high risk jurisdiction. They wanted custodians to define it. Finally, when custodians defined it, they said that this is something that you have said, so now this becomes the high risk jurisdiction. So I think there's a lot of confusion on the definition of high risk jurisdictions per se. But in the context of fund manager, what SEBI seems to be, the path that they are going down seems to be that you can manage FPI money, but you cannot be sitting in a high risk jurisdiction. So I think that is the first problem that we will need to go to SEBI with.
Right.
Unless you are able to restructure your operations in a manner where.
Right. I think the first part of the discussion we just want to discuss where is SEBI coming from.
Right.
So now here the challenge is that the PMLA regulations in their current form or shape avatar has been in existence over 2 decades now. PMLA rules to identify who the beneficial owners are on a basis of KYC, ownership and control, exist for the entire financial services industry in India. It's not just FPIs who are looking at PMLA for the first time. The entire industry, whether it is mutual funds, AIF, everyone follows the same PMLA guidelines. Now, what has made this a big issue now? The issue is that SEBI has so far, or any intermediary which follows PMLA, only applies PMLA to identify beneficial owners. If somebody has triggered the threshold, you go deeper in your KYC exercise. Never before has a regulator said that, if you're a beneficial owner, KYC is one part of it. By the way, I don't want you to invest. That is for the first time that a regulator has done using this circular that, don't just focus on KYC. Breach, go on to the next side. We don't want you to invest. Then what was the objective of the KYC? Then we should literally point out that if an NRI controls, that structure is not valid. If an NRI owns above 25%, that structure is not valid. You focus on economic ownership. Then don't use parameters set out under a different law for a different objective, which is only to identify a KYC. Those laws were never meant to tell regulators that, prohibit these investments. So which is we are failing to understand what motivates this circular. There are other ways to, direct clear ways. Instead of putting the onus back to Minister of Finance, that this is your defined term, KYC, beneficial ownership and so on and so forth. The question should be that why have you chosen that definition to restrict a class of investor from participating or a class of participants from managing an FPI? That I thought could again be the next question.
What is the status of Piyush Goyal now? Because he's temporarily finance minister now. Jaitley has again taken charge.
He will be taking
so
charge.
He will be, I think.
Goyal?
This week, I think Jaitley takes charge.
Yeah, so I think again hopefully
not a good thing. The continuity will get broken, but
that was one
yeah.
thought. Exactly. And so, but we would love to hear from others. Yeah, please.
So as a custodian group, from this entire circular, we thought the lowest hanging fruit would be the SMO or the senior managing officer. It's totally unbelievable that they would actually make the SMO as, if there is a common SMO across funds, they would make him or her as sort of the beneficial owner and then aggregate the limits. But the latest bites that we have, that indeed is the intention, and there's no wavering on that.
Yeah, I think that is
really
a big one.
unfortunate if certain key management people from Mauritius administrators, let's say directors, who are SMOs across funds, the limits would be lovely. So imagine maybe there are people who are SMOs across 300 funds, so they would eventually get 10% limits across those.
But I tend to believe SEBI is reconsidering that.
Yeah, we've been in that belief for long now, but I see it coming.
That is true, but I think they are actively looking at it. And
even Mauritius, lots of people in those entities are also of Indian origin.
Yeah.
Yep.
So it may even wipe off lot. Beg your pardon?
We also did believe that SEBI was reconsidering, but last week when the Sasritva meeting did happen with SEBI, they denied reconsidering.
The only thing last Monday was the meeting along with Asifam. They said there is a definition is going to come out of what is SMO. And then we did ask that they're having some, of course, media speculation which we cannot rely completely on. That we feel that for SMO, to the extent of SMO clubbing may not be, that seems to be the intention, which was not clarified. They said, okay, we will come out with the definition of what is SMO. So this is what we heard it as early as last Monday.
that is also true. That is also true.
I think we should at least request that if they come up with anything, they should first come up in the form of a draft. So we have an ability to react. And otherwise, they come up with a new circular again, the whole thing going merry-go-round.
So like they're doing for many other things, right? So even
Yeah,
last week there was a draft on this thing
exactly.
that was today regarding export investors, etc. But this thing,
I think since the Mauritius regulators are here, I think the most important thing to point out to SEBI and ask from a political and a regulatory perspective is an extension. Because if anyone has to do anything in terms of structure, SMO, grouping, I don't think we have enough time for our funds. And I can tell you that most of the custodians have less than 2% compliance at this point of time. So I think clients are getting worried about the deadline. And I also believe that it's the right time, and since the regulators are here, I think it's an opportunity to kind of.
I completely agree to that. The only viewpoint I have is that SEBI is being a little bit high-handed about it. They're saying that we issued a circular in April, so anyway you were non-compliant. If you are going to clarify anything, then whatever time you have now is enough. That's the approach that they are taking. But I completely agree that
but
we need more time.
Last Monday, the meeting with SEBI, and as well as last Thursday, there was this meeting with Finance Ministry, which we had along with us. I was part of it. Both the things, it was at least patient hearing they had, that the circular which will come on 10th April, if you're going to clarify something, say on 13th of August, let the 6 months start from 13th of August. This was submission. Of course, written submissions will follow this week. So if we can have that kind of an understanding and everybody says the same language, it will make an impact.
Who is the decision maker in this whole thing? That also is little. The finance ministry or within SEBI. Of course, we have heard somebody in SEBI is taking a position, and there's somebody in.
It doesn't look like it is SEBI yet.
So every time we submit something, they say we have to go back and talk to the government, and that's what it is.
this time it's not in SEBI.
Is it?
So one more suggestion. Basically.
Can you be louder?
Yeah, this is Manisha. So one more suggestion: what indirect or informal chats with SEBI and senior officials of Ministry and SEBI where is they are more worried on the who are the investors. Entire genesis of the circular, though they have hit the wrong side, but they want to know who is the investor ultimately. So when they go out today to any fund overseas to seek information, the overseas corporate says, I don't want to share the information because you don't have any local standing. Whereas they sign the declaration in the sign a form when they give the form for FPI registration that any information for regulator can be shared. But when you ask information, they don't share. When the regulator asks, so they are coming out with the genesis that I want to know the information of who's the investor, either through the custodian or directly, whichever way. So that's the ground genesis. They are trying to hit that bullet in a through a wrong side by controlling through NRIs, PIOs, and everything. But that's what the genesis looks like. So one suggestion could be, and since Mauritius regulator is here, and similarly all other regulators and SIs, which we discussed last time also in the ASMA meeting as well. Is, can we have it in the from any fund originating from overseas side, and since the fund guys are also here, that we would share the information, and that signing itself is done by in their prospectus from their investors, that any information they would be sharing it, though they on paper they sign it, but they say no, investor privacy laws are there of US or UK or anywhere from the investor is originating. So that is coming as a hurdle, and SEBI is actually not able to unlock that the entire thing, and or unlock and that riddle. So that is what it looks like in some fashion, because they want to know who are the where is the money coming from, whose money is coming.
Can I just add in this part, although it's slightly a detour from what you said, where the monies come is incredibly difficult in the fungible scenario. I.e., for example, fund of fund format, based in Luxembourg, and it has global investors. How is it possible for you to go to the next possible cent to identify where the money is coming? I can come say Luxembourg. I'm from New Horizon. I just wrote a letter, and I just want to take up feedback from what they just mentioned. Close to about $8 billion of assets. Essentially, we made a representation to SEBI, met up with them, and the feedback which we got was incredibly confusing. In fact, we found that they were playing a ping pong game, essentially putting everything into the Ministry of Finance.
Yeah.
Interestingly, unlike other circulars, this circular does not have a phrase. I'm sorry, I'm picking things up slightly more acutely. Based on advice, based on directives. There is no clause like that. If you look to Nishith, you have been in the business a little more than all of us put together. You know these things that, general circulars are based on certain parameters. Those parameters are missing in the grand scheme of things. We quiz them questions on management shares, we quiz them questions on NRI ownership. So one blatant question from our end was, it's okay for a Pakistani based in Karachi to be a money manager, but an Indian cannot be touched with a barge pole. What are you trying to convey?
Well, one of the thought process. Go ahead, please.
The other part which we found baffling was in the case of management shares. There's so much of, hoopla on management shares. Whereas they actually
Can you be louder?
The management shares are essentially ceremonial titles which have virtually no parameter except in managing the day-to-day affairs of the fund.
Correct.
Today, Mauritian regulations do not permit a structure which do not have management shares. I ask you to dissolve management shares based only on economic ownership rather than management shares. There's no single structure that's all. There are self-managed funds, but in the current regime, there is no flexibility to that extent. I have representatives of sovereigns, I have represented universities and foundations. They ask me one single question. Can we believe that Mauritius will not become the next Sudan? What answers should I give them? And this is verbatim, this is not a make-believe thing. I have no relationship with Nishith Bhai, but this is simple questions. We are questioning Mauritius' credibility down the road after this thing. And there's a pattern recognition if you look through. Last 3.5 years, with the kind of micromanagement on Mauritius is happening, it's not funny. It is essentially not seen in any other jurisdiction of similar nature. So, these are some of the parts which I found very baffling. And the vibes I have got is completely different. And I'm sorry, Tejas seems to be a little more assertive because he's met up with them in person at ministry level. But the things which we were getting, feedbacks, were completely different and worrisome. I don't have answers or solutions for it, but simple small things like management shares format as a structure. Can there be a scenario where it can be dissolved into the economic ownership? Hypothetically, even if I have management shares and I vote for a director or I vote in a meeting, in case an extreme case scenario like force majeure, management shares have no credibility. Simplistically put, the LPs will say we will create a structure or we will guide the board. They will paratroop into the picture and the management shares have no control. So then what is the purpose of management shares? It's only for administrative purposes. So can we do away with the management shares? At least that part of control, because the term control has been so widely discussed in the course of that, it stands addressed at some form or the other. We also finding issues where we recognize that the government initiatives at Mauritius vis-a-vis to India seems to be lacking in some instances. And I can tell you this part that we still haven't seen any kind of affirmative stance taken by FSC or at the government level. There's a lot of discussion which has happened. There is a lot of interaction which has happened. In this case, people are jumping on a hot tin roof. Yet, if feedbacks are not turning on, there are two issues which are turning. We want to know how does this impact existing fund structures which are pouring money into India, and secondly, what about the viability of Mauritius as such of incremental businesses coming in that direction? These are some of the hot burning issues which we think and feel are some of the areas which we need to conscience of. I can tell you with certainty, we haven't got right feedbacks, and the feedbacks are clearly reflecting that the regulators, could wait and watch more. The word wait and watch more, please underline it and with the Zurich BD24 font. It's so that essentially it's just putting people under tremendous pressure. And here you have LPs who are asking you questions. Why would you invest in Sudan or Iran?
So I think most important thing is to how do we take a collective position? Either there are two ways. We go merry-go-round because you discuss here, you discuss there, etc., etc. I think one to the extent FPI as a community has to take some action. Okay, individual representation, other things are gone, but I think a little stronger, very specific questions to be asked. That please define high risk jurisdiction. Please define X, Y. Please give clarification on this, because that is how we'll engage in the discussion. Today, what is happening is that we are saying, please don't do this, please don't do that, etc. So I think if we can just have some more like cross examination, that we need clarity on this subject, we need clarity on this subject, and then very specific questions. If we can come together and either some organization is set up or individual members need to sign off, because somewhere we all have to take a position. I remember even when the text really a similar situation 20 years ago, because I remember having involved with Mauritius in 1993 and all that. When monies were coming well, it was going well. Then suddenly, tax department began to challenge, and matter went to Supreme Court. Now, no individual member was willing to come forward. So ultimately, an organization was set up called Global Business Institute, and then we represented in Supreme Court GBI. I think you all know that. But that really worked, because the first question was whether it has a local standard, and Supreme Court says yes, it has. We started off from that. So then there was a full force that these are the people and this is how it is. So as an organized body, I do not think we have an FPI kind of any body or organization, right? I believe that some people are making individual representation, some other groups are making representation. So there is no coherent approach. If I may, if there is any.
You're absolutely right. I don't think there's a coherent approach. I've heard of a few individual bodies being framed,
Exactly.
informal bodies being framed, and I think that is again leading to the problem. If he's not getting feedback, it is because he's approaching as an individual, and thereby the separate set of individuals would be interpreting it differently and asking for some feedback. So I think we all need to write to SEBI or to the Ministry of Finance or to whoever individually, but more importantly as some sort of an organization. That is, I think, something.
So I think, is it a good idea to have some? It doesn't have to be incorporated now. That even as a group we can name it, and but something quickly can be done, because uh, difficulty is that when individual representatives, they are talked in different ways and somebody else talks different ways, like I and Tejas, and we have all been discussing very coordinated way, right? But when somebody goes and makes some statement, somebody say, okay, give us grandfathering, right? I'm not against or for, but we have to take a position whether they're asking for grandfathering or not. But grandfathering will not solve our problem, you know. So people may make different suggestions, which everybody may or may not be in sync with. But I think if you have now some kind of a body, it can be set up, or say a FPI, federation. I don't know whatever you want to call it, or something can be done. If that would be very helpful to, because even government, whom is it talking to?
Just to add in part,
Is there something that we should be
just
doing?
to add in this part, this experience which I had, where I represent about 8 or 10 funds put together, about 12 funds put together. Why I'm highlighting this part is something similar representation was made in indirect transfer of assets, which happened from a tax perspective. There, the reception was much more assertive. Mr. Sriram called me up, though he was not directly related with this matter earlier because of Morgan Stanley. And the representation was made, they heard us out and they immediately incorporated relevant changes in the ensuing budget, which was within a matter of 2 months. So there was an immediate feedback and an output turning up in that direction. And those things are completely missing in the current scheme of things. So I don't know, as he highlighted, we don't know who we should be talking to also. And are they the guys who are in a position to make decisions? Both these elements are missing in the current scheme of things.
So we have two systems. There is faceless decision maker and there is a faceless audience to whom government would also reach out to. So I think if we can have some kind of...
So the one that which we were involved in went under the name of Asset Managers Roundtable of India.
I think that's a...
So I think one way is to just add to that if everybody's objectives are aligned, or we can think, whether we want a new one. But there is already something formal which has gone
I think
under
that's
that.
a good idea. We should actually look at that. There is some sort of an informal body which is being Asset Managers Roundtable of India. I think just like that.
Whatever, I think.
Or rename that or whatever.
So I think it can go under some kind of a letterhead of association of asset managers, roundtable. Roundtable, I think it would be.
AMRI.
Actually, there's a Twitter handle also which has been.
So whichever one, but government also will know that this is the body with which they should actively engage if they are deciding something. So
I think it's already there, but I think there will be strength in numbers clearly. I think that AMRI has already been formed. There will be strength in numbers if we can add to it.
So currently representatives are going in the name of AMRI?
Yes, correct. I think 2 representatives have gone. One to SEBI, another to Minister of Finance. We drafted.
Correct, absolutely.
So I think if it is there, then I think let everybody be part of it and, we'll circulate to the, and at least the email ID group can be prepared and something can be done, right? Some formalized, and then, who will be representing on behalf of AMI? 2 or 3 representatives, we can have a convener. Let us call conveners. 2, 3 people are conveners, and then I think we can just, is that okay? Because that is one action point that can come out. So henceforth,
so that body represents to SEBI, MOF at the same time, so that everyone can sort of endorse the view and not play a passing game that it's between SEBI or MOF or RBI and so on and so forth.
No. I would actually be very keen to see how Mauritius also undertaking this.
That is a separate
thing. Because there has to be a government initiative in these aspects.
Yeah, go ahead.
Thank you.
Sorry,
no, it's okay. So, this April 10 circular is a lot of problem for everybody. Even the regulator regrets issuing that circular. As soon as the circular is issued, FSC has taken it up at the appropriate level, at the government as well as with the SEBI. It is not right, government has not taken. Even the FSC, government of Mauritius has taken up with the High Commissioner. The High Commissioner flew from Mauritius to Delhi to take up the matter. The matter appropriately passed on to the SEBI. And FSC as a team met SEBI officials. They have confirmed or clarified that we are not going to come up with a common list and Mauritius won't be there in the high risk list. And subsequent developments happened endorsed that commitment given. Even before this circular, every custodian has its own classification of risk jurisdictions, and that will continue. So there is no change to that. In a way, the confusion created has been settled on that matter. Second issue, mainly we are talking about is the ultimate beneficial owner matter. This is something nothing to do with one jurisdiction. It is common to all. And as far as the interaction with SEBI, the allegation that information with respect to ultimate beneficial owner is not available is not right. SEBI in various investigation matters contacted FSC Mauritius, and we have a good working relationship. Mauritius, the FSC won't keep the beneficial ownership, but the management companies. We write to the management company within 24 hours, the ultimate beneficial ownership will be at the FSC, and within 24 hours, we pass on the information to the High Commissioner. So that kind of working arrangement we have. So SEBI has no comms with respect to exchange of information with FSC Mauritius. That I would like to confirm, because I was a SEBI man and I was FSC. I was the acting chief minister for more than 2 years there. So I have good working relation with both the regulators and also the government. So that concern is not there. The issue, what happened is that the circular was, SEBI generally issues circulars or policy decisions after a consultative process. They will issue a research paper or a and put it to public circulation and take a regulatory view. But in this particular case, as somebody has pointed out, it has come from above. That is accepted fact. So many points are missing in that. So when we talk to SEBI, what SEBI was saying that we will take it up with the Ministry of Finance. They realize the dichotomy or the discrimination with respect to Indians against foreigners. Foreigners were treated more favorably than Indians or Indians of origin. So SEBI realized the mistake crept into in that particular circle and given us an assurance that they will take up the matter with the government of India. As a regulator, FSC can't put more force on that because it is India government's prerogative to take any policy decision with respect to who will invest or who want to, from whom we want to take investments. As a regulator, the Financial Service Commission has nothing to do with that. But it is affecting our license holders, our funds based on that. So that is why we have taken up that matter, and SEBI has given an assurance that they will have a relook on the issues. And my feedback I am getting from the industry is that many representation are so far gone. My only issue is that as a Financial Service Commission, as a regulator, we can't be party to the representation. That's all what I want to make it a point. And I encourage in a way market operators or market partners making the representation.
Just a point here. Number one, the whole problem begins with the fact that SEBI says that we are not going to come up with a list of high-risk jurisdictions. That is the starting point. But what they've included in the regulation, the expression high-risk jurisdiction.
Yeah,
and they have, so to say, delegated it, what I call regulatory discretion, to the banks, okay, without any, what is called,
prescribing the criteria.
without any judicial scrutiny, because discretion, if it is to be exercised by bureaucrat, you can challenge if it is not judicious. But if it is a private person, then it is not. So the whole problem arises because regulatory discretion has been delegated to a private party. And there is some kind of a precedent long back. Some of you who are in the business in about late 70s, there was R&D cess that was levied, research and development cess, some technology transfer agreement. Some of people may not have been born per se, and I'm not that old, but the R&D cess that was imposed, and that was to be collected by IDBI. So the challenge was that you cannot delegate revenue collection to a other body, So it has to be only done by the government, and that is why they could not succeed in collecting R&D cess. For a long time it remained, even after liberalization happened, that R&D levy was considered, then it's somewhere on the line. So here what has happened is that SEBI, we have to say that if you include, high risk jurisdiction as an expression in the regulation, then you have to take a call. Okay, if you leave it to bank, how will bank have their own compliance department? Some department will consider it high risk, some department how does. So from Mauritius perspective, I think what we need to do is to at least raise this question that we are a very compliant jurisdiction, cooperative, blah blah blah, but we also need clarification. Then, because a relationship is just not political, it's economic relationship that is getting disturbed today, in spite of our having done.
It's a very valid this thing. SEBI should not use the word high risk in jurisdiction that circular, because high risk jurisdiction is something that the regulator decides. The global banks, they have a criterion of countries, jurisdictions, and it is not for one country one criteria. It is universally applicable. If the HSBC decide classify, it is for all world. From every jurisdiction it is applicable. So they can't have a high risk jurisdiction only for India list. That list should be universal.
But there is no common criteria for all banks. That is the problem.
Yeah.
Therefore, I'm sorry, just
one
once.
here.
Yeah.
Like in India, you also don't have only banking custodians. You also have non-bank custodians.
Correct.
Now, where that high risk, how it can get defined for a non-bank custodian is a question mark, right? So the high risk necessarily has to be mentioned so that the custodian bank, and as well as the non-bank custodians also can follow.
It is their internal risk management criteria. I don't think we should be too much worried on that. It is.
The thing is, regulations cannot be based on
Yeah,
internal
that point I
criteria.
agree.
That's the only thing we have to
They
point
should-
out to SEBI.
Yeah, they have to remove the circular entirely, because it is not only virus, everything is wrong in it.
So that was the point we had made. It should
That
be
is the
withdrawn
exact. It
first
is
and
not only
restart.
virus. The entire circular has been issued in a wrong base, I would say.
But going by the experience with SEBI, SEBI never withdraws anything. SEBI might go and dilute something, but they will never withdraw. So I think that itself is an expectation which is high risk.
What to me, what is going to happen is that they are going to come out with a new circular, amending it. Amending it means that new circular will repeal the old one. In this particular case, that is the only way out. So it is not that we are not making an attempt to apprise them of the facts, but it is also for them some ego issues there. No, but it is only a matter of time. I expect before October.
I think one suggestion I would have is that if that Emery, if we can ask very specific questions to the bank, to SEBI, to clarify, apart from high risk jurisdiction, the implication, what do you think so? So very, very precise, pointed questions that SEBI is expected to give us. That what happens when out of 10 banks, 2 banks classify X jurisdiction as high risk jurisdiction, how would do we expect them? Because how will they even consider? Because there is nothing under control of the local custodian, or it comes under compliance. So they also have their own obligation to follow. So in these circumstances, how will the whole ecosystem work? So we can write down some questions, okay, and what are the implications of that? So and in short, so if they have to answer these questions, then they will automatically resolve some of the problems, I believe. If and apart from the high risk jurisdiction definition, even the NRIs, for example, and then that is it intended. What is the purpose of the circular? Is it intended that no NRI or the NRIs are bad actors, or is it at one go they are not? What is the intent of the circular? For the first question we should ask, what is the intent of the circular? Number two, while implementation we are confronted with this problem. What is high risk jurisdiction? Okay, because different banks are taking different views, that's all. Number three, that NRIs, that all NRIs at one brush they are bad actors or not. Let them clarify, it's, whatever best way we can write, but 5 6 questions, because they are answerable to these questions. Here what is happening, we go around in circles, and oh, they must be thinking this way and they must be thinking this way. What, you know so if we can have 5 6 questions, that we have some clarifications to see what is the purpose of the circular, what is the objective desired to be achieved. Okay. And number three, all these specific 2 3 4 questions, I think.
I think also, Nishith, what you raised earlier is the definition of control under a money laundering statute, the appropriate definition to apply in this circular. I think that's also causing a lot of
So
problems.
all the questions, whatever question you think we should ask, let us collate, we together then converge, and then we ask them that these are the clarifications we need, issues arising out of that. Then they will be on the spot as well. Sorry.
If I may come in here, so just to try to, I would say, put it into more some perspectives, that we've heard about AMRI, right? AMRI is the body that's going to take it forward. So we need to understand the firepower, I would say, of AMRI, because what we see here, for instance, that SEBI has come out with a circular, but we hear it is not from SEBI, it's from higher quarters. So probably there is a need to meet not only with SEBI, but meet probably with the Ministry of Finance and other stakeholders who are involved into that. So for AMRI, like to have a sort of common meeting, common platform to meet all of these people at the same time, so that the same message goes from the industry to the regulators, to the authorities. I think the questions that will be put has to go in the same way that everybody understands the same thing. And then when the message comes out from them, then it will provide more clarity as to who to approach at the next level, whether it's still with SEBI or the Ministry of Finance, because we also know that, like just you mentioned that you met with Piyush Goyal, but now that Jetli is coming in again, so it's another set of also context that will be roped in. And you have to also remember that when the treaty was revised, I mean the treaty was reviewed in 2016 between Mauritius and India, it was under Jetli's supervision that was done. So I think all that has to be taken into account, and then probably for Emory to meet with all these stakeholders on one single platform instead of meeting SEBI on one side, the Ministry of Finance on one side. So I think that's very important also.
Another challenge that some of the clients are facing vis-a-vis what is required as per PMLA and what is there in the April 10 circular is that you need to still do a look through even on a listed company basis. So that is another point that I think is important, because SEBI specifically told us verbally that they have not provided this relaxation in the April 10 circular very purposely. And this is different from PMLA requirement where you just stop at the listed company level and don't go beyond that.
NDA, for example, how do you? Yeah.
So I think these are very important questions, but if we can put them in the, what we should say, this circular has caused enormous amount of confusion in the marketplace, and we would like specific, clarifications on the following point. What is the object and purpose of this circular? What is the implication of this XYZ thing with high risk jurisdiction, or what about the listed company? Including, we should include all that. So later on, we don't have to come back, because when they have said something orally, you cannot hold them accountable, no? Because you assume that will happen, then they we never told you this. So, although it's very simple and no-brainer to say that in a listed company you want everybody's KYC to be submitted, it's a little tricky. But at least we should write down and say, okay, these are replies, we can act upon it, banks can act upon it, and people can act upon it, and large amount of funds have been raised.
Regarding NRI and PIO being beneficial owners of an FPI,
yeah,
we had given one suggestion to SEBI, which I think they liked it and they're considering it, is that if they had if they have a FPI which is advised, or there is an investment manager which is ultimately owned by an NRI or a PIO, then you get that investment manager registered as a category 2 FPI in India. So by doing that, at least it will be under your ambit, and by FPI regulations, you can ask for any information that you want. I think SEBI like this idea, but I don't know what far they've gone to kind of.
Yeah. Is it different from what the April 10th circular anyway says?
Yes, it is.
So it does cover a criteria of non-investing FPIs, which is available in the FIRA regime, which is being revisited in the current context as he suggested.
Right, but how is it different from what?
So even if you have a regulated fund, right, they don't need a sponsorship. Correct. And if their investment manager is like owned by NRI PIO, you get that investment manager also registered as a category 2 FPI in India, by which it comes within the ambit of SEBI. And SEBI has all powers to kind of ask for any information.
So here is that process of sterilization, what he's trying to articulate.
Right.
I think this is what we have written our representation also,
Right.
a concept of non-investing FPI under this new regulation. But we haven't heard back from them, and of course, my feedback and my letter was a while back.
See, I think I can clarify to you a couple of points. What the circular says and does not say. What the circular need not say, because it's a continuation of the position, is that if an entity has been set up in any jurisdiction, it is not appropriately regulated by a regulator. And SEBI has benchmarks for Singapore, it has come out. For Mauritius also, it has come out with its views about investment holding company versus a collective investment scheme.
Sure.
So there, SEBI's articulate position since beginning through regulations and FAQs has been that if a vehicle which is directly investing into India is not appropriately regulated, then in that case they can always rely on that vehicle being managed by a manager which is appropriately regulated.
Correct.
So it is already an enshrined principle with SEBI that please set up a appropriately regulated non-investing manager so that they can sponsor in turn the FPI's investment program into India as a Cat 2 FPI. What this circular goes one level beyond. They say that if an NRI owned entity is managing an FPI, then please register yourself as a non-investing FPI. They don't comment whether that vehicle has to manage a non-appropriately regulated fund. So that is one differentiation that I wanted to point out. So this April 10th circular only says that if you are a manager and you are NRI owned, register yourself as a non-investing FPI. Yeah. They don't say that only if the fund also you are managing is not appropriately regulated. So that's the point. If they can open the relaxation that if you are registered as a non-investing FPI, we are fine with even Indian ownership as a beneficial owner from a control perspective. That would be a significant.
Absolutely, because if you marry in the 2016 income tax regime, which talked about 15, 19 points,
right,
on getting on board, how would I hypothetically sitting here in India as an AMC have a downstream subsidiary in Mauritius to manage an offshore fund or directly manage an offshore fund without having a control on management shares? I mean, it's just not possible or viable in the current context.
Right. See, I think the only difference there is that under the current PMS program, where as a portfolio manager, if I'm an agent of an independent nature,
correct,
as a portfolio manager, I'm no different from a custodian or a bank who's providing similar services to a lot many other clients. Then it is possible for a portfolio manager to have a mandate to portfolio manage different institutional clients.
Correct. But what I'm coming at is also it just puts. There are other layers and other options available currently. Where you can have a downstream subsidiary sitting in a jurisdiction like Singapore and Mauritius to do these things for a bread and butter.
Right.
Some of these circulars which have been brought on board defeat that very purpose of that objective. There are many instances where these so-called mandates insist on the term skin in the game.
Right.
I didn't see that word coming through in the forum here. Because of that, essentially, you have an NRIs or
crossfire.
And this is a business proposition.
Every fund, skin in the game.
Absolutely. In fact, I'll tell you
this is a business proposition.
I'll tell you the absurdity.
Proposition.
Yeah. I'll tell you the absurdity of the situation. So for another client, we had a representation with SEBI just on this circular. We said that to begin with, the entity had to be regulated by a financial services regulator. If you want to make an outbound investment from India into financial services, the first requirement is you have to be regulated by either SEBI or RBI in whatever capacity. Then you have to approach your financial regulator for a specific approval that please allow me to set up a subsidiary abroad for XYZ activities. That approval that eventually comes from the regulator will also say that you will never round trip, you will never have any single dollar proprietary capital being round trip through those structures. So that's the second leg of regulatory check and balance. That approval requires that your subsidiary has to be also be regulated by an offshore regulator at the same time. So whether it is MAS in Singapore or FSC in Mauritius, there's a third layer of regulatory overview And all three layers are under IOSCO framework, right? Because you are being regulated by different appropriate regulators. Then when they set up a fund, eventually, which is going to be an FPI, which earlier was the FI sub account, that again requires a SEBI license or a custodian or a DDP overview. And then when you invest in India, you're again investing under the SEBI format only of FPI.
Just to put things in context there, nobody in this room is trying to limit or restrict regulation. Nobody in the room. I don't know any of them in personal capacity. But nobody in this room is trying to restrain or dilute regulatory oversight. But the KYC has to be uniform and has to be a little more reasonable in the context of doing general business. You are asking me to be transparent. You are asking me to be naked in the current context. And I still don't know whether I'll be able to pass through the test or not.
Right.
Because the test has numerous permitted. Here it is all about interpretation. Let me put it this way. This circular is putting things, and you're being a lawyer, you know these things a little more conveniently than us. These things are putting everything under interpretation.
Yeah. No, that and see the point I was trying to make that for an Indian resident group or entity to even be a beneficial owner of an FPI, what does it take? It takes 4 rounds of regulatory approvals. So KYC is one part of it, but the entire philosophy that we don't want Indians to be managers to FPI program and so on and so forth. And there was a very specific FAQ also issued to that effect under 114. They said Indian residents can be
correct, which is why I asked this question in my letter itself. That very FAQ raised this issue for me.
Right.
Resident Indians were also permitted in that context. And the question here is of round tripping. You can seek a clampdown on round tripping, but why reduce legitimate businesses for NRIs, PIOs, or senior managing officials?
Correct.
In fact, at the Mauritian level, what you need to probably ask yourself is that the exact role requirements of the senior managing official. That puts too much of spotlight for locals who are managing money or on board seats. That part I think you need to take up with the local regulator here in India. Because there could be a case of an individual, say my friend Tejas is on the board of Aberdeen as well as Morgan Stanley, and it could be just blanketed and put under similar percentage thresholds.
I think that one thing is something which can lead the markets to collapse, because if you're going to combine limits across various funds managed by the same manager.
He's doing a fiduciary capacity. He's not got he's earning his $3,000-5,000 or whatever that fees is.
In fact, that too is a big departure because before the April 10 circular, the rule around clubbing of investments for FPIs and P notes together was commonality or overlap of 50% economic ownership.
Yes.
If the economic owners were 50% or more across FPIs and then P notes were also clubbed later on, that was the way to club. But now they're saying that all these different parameters of control, senior management officers, and economic ownership of more than 25% or 10% in a high risk, all of them tends to lead to clubbing.
Just one. Go ahead.
Sorry. The other issue is, they've put these limits of 10, 15 and 25 for a single person to be regarded as a beneficial owner. But the other issue is that collectively, if in a India-focused fund, if the NRI ownership in aggregate is exceeding 50%, then what happens?
See, I think I can only share our view on this one.
Yeah.
So I think again here SEBI's stance has been somewhat clear. Clear actually. Whether it was under the old FI sub-account regime or whether it was the regulations or the FAQs that have come out. I think in their mind, SEBI has been saying that we don't want corporate entities, which are companies. And when I say companies, I don't mean fund set up as companies, but which are companies, which are not blind pool vehicles, are not meant for pooling global investors and so on and so forth. It's something where you internally manage your entire affairs because you're a corporate entity. There, they don't appreciate NRI participation because it's a very intrinsic structure.
Because they're all OCB type entities.
Absolutely, absolutely. So there, because you are not broad-based, so to speak, you tend to be a category 3 FP, and hence, companies owned by NRIs, which are more in the category 3 FPA nature, should not be sort of looking at this regime. On the other hand, if you are a blind pool vehicle, you are a fund which is being marketed, you are part of a global LP mix, then in that case, if you are broad-based, you come through category 2 FPI and hence you are a fund and not a company. Not how the fund is set up as a partnership or a company. Then in that case, NRIs as a class should not have a restriction.
Absolutely.
Just to put this answer in perspective, there's also no other alternate regime to do this. Under schedules 3 and 4 of foreign investments into India, under PIS route, portfolio investment scheme route, NRIs as an individual or on a non-repatriable basis, a company wholly owned by an NRI can invest in India. But for NRIs to participate in a fund, there is no other regime but the FPI program. So it would, this view that I just summarized, not just our view, would be in line with also how the regulations also structured. But again, I'll defer to what other views are going around on SEBI's view on this.
Yeah, I think there's some bit of confusion, whether they are relooking at it and whether even they will apply this
See,
criteria to a
let me put
broad-based
it this way: if the circular does not point in that direction, I think we have one less issue to deal with.
The circular reiterates that FAQ 91, which was there earlier. So that is leading to the confusion.
The
See, have they
iteration is
changed
the
them?
original FAQ that says that a company owned by NRI is a problem, not a fund. There also they have been clear in the other FAQs that a fund can always have NRIs as investors.
I think market participants are a little bit worried because of the spotlight on NRIs. Whether SEBI will have a challenge with those purely broad-based structures as well. So we can consider whether we want that clarification.
I think let us frame all the questions, okay, and say this circular has caused enormous amount of confusion, and for us to conduct our activities in a professional way, we would like you to clarify this. So we can interpret circular also in light of the objective, okay, and then other thing. Second thing, apart from that, I would think, is there any need or you see engaging with Singapore, because they are also meeting us next week, and with MAS or otherwise, because if it is one part is to what extent it is high risk, I do not know, because high risk also include tax haven. Singapore at one time was considered tax haven, okay, because 17%. And
So China featured in that list.
China has
Singapore, I
featured.
thought, was not there.
But Singapore, is there something that can be, for example, NRI issue will be applicable even to Singapore funds. And in fact, there are more persons of Indian origin in Singapore, perhaps than in Mauritius. Mauritius maybe 3 generations beyond, I don't know. But here,
They're absolutely
there will be
NRIs.
most will be in last 3 generations, the managers in particular. So I don't know how much Singapore is also concerned about this circular. And we can engage them as well if we all think that it will be worth doing that, at least, so that was my second, if you want, we can perhaps convene similar meeting. And because we can know, similarly, Luxembourg is a classic tax haven. So it would be worthwhile, I think, this list is available, right? Different banks have different lists. So, we can say that in their own judgment, whatever that is one thing. But how do you behave yourself? We have to comply with law, and that makes it difficult to, and the process, the investment supposed to be coming. Now, how should it be happening? Do you want investment or do you not want investment at all? So, I think, if you don't mind, I think let's do that, and perhaps sometime in the next week or so, if we can have another meeting, even with Embry or whatever. So we all have thought of it. We create something. We circulate. First, let us run it to Tejas, and then you can circulate to everybody else. So we converge and we can together come back. So that would be very helpful, I agree. Yeah. So.
Every umbrella, the letter is signed by Nandita. So we just need to get her on board.
Yeah, okay. We'll say this is what we discussed. We thought that one body should be the face of the industry.
Yeah.
Because the government also will be otherwise talking to people who are not relevant.
Completely.
So we'll talk to Nandita and just that we can.
We should get this out to SEBI and the Ministry of Finance before the change happens.
My thinking is within next 2 to 3 days, we should have our questions ready, and then we circulate amongst everybody. So by the end of this week or some whatever, people can react if there are any questions to be asked. Very pointed questions. Correct. And number 2, about the Embry thing, we can clarify. And sometime next week we can meet and we'll send out those questions. We won't wait for meeting to take place. But I think at least on a weekly basis, if there is some meeting that could be done like this, we can always circulate and have too many emails going around, and then everybody reply all, and then So
I only request, considering that we have only 6 to 8 weeks left,
That is right.
Okay, so maybe, and I think everybody seized of the issue. You will find the response coming from us very fast. We don't really need
I
to
know.
wait for
Correct.
a week or whatever. So within 2 days, if the questions can come out, I think within a day everybody can respond. I see a lot of clarity of thought here.
I need to take, he's absolutely right. I also need to take a pinch of salt here. Hypothetically, if there's some sort of clarification which comes out on the first week of October, and our current custodians are on this side and given a clarification 2 days in advance, they have a timeline of 9th of October or 8th of October, where they be up and running. Are they in compliance or not through a DDP mechanics? So are they in a position to handle this kind of volume?
Well, 9th of October itself is not a realistic deadline because you have 10,000 FPIs and you have to upload that information on KRA who has to then verify it.
I think they would be somewhat reasonable. I hope so, that.
Hopefully it won't be first week of October before we get some clarification.
So I'll tell you what I have heard, at least what I'm hearing is that SEBI is definitely seized of the matter and they will issue a clarification. They were looking at something like end of August. So I think
end of August, September, that was my feel.
Very limited time.
But before they issue, we should tell them that please issue a draft circular for our review, at least that much. And then we can get consult so that there is less confusion. And these questions we need, and if you issue any clarification, then please also let us have a draft so we can interact and come out with something that is.
Whatever dilution is coming out, like Vikas rightly said, they don't likely to get withdrawn, but some dilution is.
I've been hearing about SEBI coming up with some clarification.
For last 2 months, 2 months, I know.
Nothing to say that it will happen tomorrow or a week down the line.
But I think we should target next week to send out something.
Yeah, maybe end of this week. I think it's Monday.
We wanted some statistics, total FPI investment and FPI through the NRI.
There's an article which came in the Economic Times, which I think is.
If we were to put a number, like how much of NRI controlled FPI flow we've seen, or Indian resident, to be honest with you, even that is the other segment which is affected. So combined, are we looking at 35, 40?
Mauritius, I think we Mauritius numbers.
One number will be 40 to 60.
Just
I was looking at 40 to 60.
40 to 60.
Mine, but I mean, check with others. 40
to 60 billion.
Yeah, but NRI in India, beneficial ownership.
Only that sphere. But total FPI would be all.
Total FPI would be obviously
9,000 plus.
Total investment FPI 450. Total number of the value 150 billion.
450 billion. So at least that number, whole thing is that this segment is very important to be addressed. That's
so
why
10
we
to
are
15% of FPI flow.
My number, sure. Check with the rest.
Economic Times article actually talks about SEBI circular has the potential to hurt a part of portfolio flows worth 75 billion, or 20% of the total FI flow that is coming to the Indian market. So whatever it's
that can be quoted.
That is a publicly accessible source.
We can source also is there.
I just sent this article.
So it can be the starting point. So it is important issue to be addressed. And, so I think should we zero in on some date next week?
Sure.
So at least whoever can make it will be good. Let's say today is.
But during the course of the piece, we aim to achieve the full circulation of the questions and some responses. And
all that will go on. But I thought that it might be useful to get together. Because what I feel is that it's very difficult to go back and forth. Of course, an email we get feedback, but then what is the final conclusion will still remain. Somebody has experience, bias, some other view. Then so if we can just get together next week, that will be fine. 20th is okay. Monday. I think Monday is a better day also because they start their day, so we can whole week is available for us to take further actions. This week is some holidays, so we'll try to come back as soon as possible. 3 days is maximum by Thursday because 15th is holiday, but still we'll work. It doesn't stop working anyway. So and we'll talk if we can have Singapore people also join. We'll see that.
Will it be possible, Nishith, to get questions before end of this week?
We are trying to do it before Thursday, not even before immediately after day after tomorrow, that is 15th of August and 16th.
Your Minister of Foreign Affairs is coming to Mauritius this weekend.
Yeah, this Mr. Swaraj is in. So we already prepared some basic this thing, some points.
So we'll be meeting with the
Because
Prime Minister and herself. So I would like to get.
Prime Minister also coming there, no? Guy was there. Okay. So, it can be raised to that level that this is really affecting the not only one is political but economic relationship between the countries, which is the
because the questions will be sort of concerns that we have to raise at highest quarters. So if we get these questions before that, we can raise it during meetings.
Just to add is what we have done is that we from a regulator to regulator FSC is leading, but we're also having industry participants who have been we have regular workshops with them to discuss on all these issues just like we are doing here. We engage with them. So I think we are also having the political side as well, which is done at a higher level, but for which we provide input to the ministry that escalates the matter to the Prime Minister's office. So definitely like taking the current local industry, but if we have your input as well, then we can collate together, have one view, and that will give more firepower to the arguments.
That sounds good.
Any view on the AR Khan committee? I mean, that was the committee again constituted for the legalization of the HR Khan. Any updates on that?
So there has been a meeting that has happened at SEBI. SEBI had called across few of the banks with regards to merging of the NRI PIS scheme with the FPI framework. So there has been one round of meeting that SEBI had with the banks to understand what are the challenges with regards to merging the NRI. If that merger happens under the FPI regime, then whatever issue that we are currently facing on the NRI being kept out of the FPI framework will get resolved. But there are other challenges where there are hardly about 15 odd banks which are custodians today, whereas there will be almost about 40 odd banks who are doing NRI business.
Most of them public sector, right?
Yeah,
most of them public
it was specifically mentioned to banks that they will not discuss anything related to the 10th April circular in the HR Khan committee. But about a couple of weeks back, I think directive from the board, based on representations that they have received from various members, I think they are now discussing KYC related issues, including 10th April circular in the HR Khan committee very actively. The next meeting, I think, is tomorrow.
And all this is leading to a redefinition of the NRI as non-reliable Indians, right?
Yeah.
And they are supposed to come out with a draft of their recommendations by end of August.
Yeah,
which is where the whole end of August timeline kind of marries. So that they are not seen to be amending this 10th April circular, but issuing something more comprehensive. That is
for
game plan.
Larger political economic relationship perspective, will it be a correct statement to say that approximately $450 billion are invested in India under the FPI regime, and of which $75 billion are invested to NRI or Indian resident control entities, although monies do not belong for the management purposes, and therefore this issue is of very high significance for both countries to sort out, because that's at a Mr. Modi and Swaraj's level I'm talking, because they must pay attention to this. They should not delegate it just now to minister level. Now it has become a major issue. So I think if we make that what do you call it, proposition, that's reasonably accurate, right?
Right.
Again, the numbers out there.
On the basis of that, correct. So I just want to say that why they should be involved in this, because it's a large.
So just once that $75 billion will be across country. So there could be some NRI, PIOC.
So this issue as a whole.
Yes, exactly.
Because NRI is any country, whether Singapore or US, they just can't. So 75 billion is cut out of the 450 billion, right?
Nishith bhai, just a small pointer to that part. Besides the $75 billion, even the residual amount is at risk if you were to consider senior managing official aspects. Yes. That's where FSC needs to step into the zone very clearly, highlighting that this can actually ambush even a conventional mutual fund which is operating in the US and has some board seats which have commonality with other competitors.
I think very valid point.
So you are not just really reading only in one silo. You're dealing with other aspects which is even more dramatic.
If the rupee goes to 80, then it will be a political catastrophe completely for the government.
Yeah. So I think that also
just to highlight that not all people living in Mauritius are people of Indian origin.
No, I don't dispute that.
No, what really is it's discriminatory when you in Mauritius it's really reflective.
No, I completely agree with you. So they're using a broad brush to taint everybody, and that's why you use the term non-reliable in Indian.
Yeah.
You could have an issue on round tripping with a foreigner also.
Yeah, Nigeria is fine, but Indians are not.
So we will put at a low pedestal, merely because of a lineage, resident or non-resident, as the case may be.
But on this meeting, you are having to sort of clarify, to have a commonality in the questions. You are fixing it for the 20th. It will be after the visit of the foreign minister. I just wanted to highlight, is it possible to prepone that meeting a bit earlier so that you have the questions finalized?
No, questions will give you. This is a physical meeting like today. We thought we'll have on 20th after 1 week. But by circulation, we'll be having this question circulated and it will go to all the people. If you all could give email or whatever, I don't know, we have this thing, right? Anyway, so we'll circulate to all. If they feedback, by Thursday we'll finalize questions. And some kind of I've already drafted something for, Richie will give you, I do not know. But we'll improve on that and give you so that can be handed over to. And I think first part to mention is that why this issue is so important.
Yeah, I think that will be
is it impacting so and based on that, these are the questions we are looking forward to. In fact, one way to look at instead of this body giving, you can also say that we need these clarifications. So it can be given at a ministerial level, so they are compelled to answer it actually, and then I do not know what's a better way, right? So. If you think in order for us to have proper thing, these are the questions that are needed to be responded. Let us have questionnaire first and see who is an appropriate person to ask.
Yeah, in fact we can.
If you can ask them, nothing like it, because then
my government knows that I'm here. My government knows that I'm here. So I can say we met, we discussed, and these are the questions that have been asked. And we need to answer. So it can be thought not only Amri sending the question, it's this meeting, our concern that I collected while I was here, and these are the issues. So for me, it can be taken.
Yeah. And next week on 20th, let us see if we can get some Singapore MAS people or other people can be involved. And if somebody is coming here, it's fine. Otherwise, you can come on video. I know, to come again, I carefully recognize that. But at least you can come on video and because now you are familiar with the people and the issues. So, and I think that we should seek a meeting with SEBI. This is on 20th, so about 24th or 25th or something like that. Before the last week starts now. So
to discuss
with Emery,
yeah. 24th is Friday.
Friday is okay. 24th.
24th or 25th, so I say 24th is Friday.
So if we ask for the date now, maybe today or tomorrow or whenever, and so at least if they are going to issue some circular on 26th, which is the new
week.
As he said that last week or something, at least there is some rethink. Yeah, that they were meeting. So let's see. Thank you so much. Anything else? Yeah. Okay. Appreciate. Thank you so much.
Thank you very much, and I hope we at the end of political discussions, our meetings with the foreign minister, and we have meetings with SEBI also. We are going to convey. We try our best. We cannot force any regulator to whatever. But
when are you having meeting with SEBI?
I think it will be some 1 month's time, something like that.
Not tomorrow. But
No. It's harvest coming.
It's going to be before October.
Yeah.
It will be before.
No, because more you understand the issue, you'll be able to deal with SEBI better,
It will be in about 1 month's time.
Because last year they made us all happy saying that no, we are not getting into we are not going to come up with high risk jurisdictions. So everybody went happily.
Yeah. No, it was.
We did not solve the problem.
Okay.
But once you participate, you will realize what exactly is
all the issues.
Okay.
No, we'll handle that. Thank you very much.
Yeah.
That's all for the best.
Thank you very much for coming over. Appreciate it.